Good morning, everyone, and welcome back once again to yet another session on polity and constitution. I hope I am audible as well as visible. Okay, let's begin now. Starting with a quick recap of what we studied yesterday. And as you can see, the session is from 10 to 8, right? A longer session. And we'll try to cover a lot of ground today. Largely fundamental rights. It is a slightly longer topic, and we'll try to uh, cover as much as we can. Don't worry, we'll have proper breaks. We'll have a lunch break from 1 to 2 p.m. so that you can have lunch, maybe take a nap, not too long a nap, and then one more evening break from 5 to 5:30. And we'll keep on having regular breaks in between. Am I audible to everyone? No problem with the voice quality, decibel levels, all okay. Great. So, if there is any concern, please refresh your screen. That would solve the problem at your end. This is not the last class for polity, guys. We have a class on Tuesday, right? So, please, and if required later on also. So, this is not the last class. So sorry, you'll have to see more of me at least for few more days, right? Okay, so let's begin now with our topics at hand. Yesterday we had taken up for discussion uh, articles. Of course, we started our discussion on center state relations. Once we moved on, we also discussed the fundamental rights. Why are they called fundamental? What's the difference between your legal rights, constitutional rights, fundamental rights, all this stuff? Then what is a state for article for part 3? Then the concept of basic structure, which is an innovation by the Supreme Court has thought of this concept on their own. Then we also saw article 14, article 15, and we are looking into article 16. We had seen article 16, but some associated elements were left for discussion, right? So the last topic was the scheduled castes, how to categorize the scheduled castes, right? We'll start on the same point today, how to categorize scheduled tribes and SCBCs or OBCs, and then we'll move on to look at the Indira Sahani case or the Mandal case. Beyond that, we'll also then look at other articles under fundamental rights and their associated issues, if any. Okay. So let's begin now. This is a regular, this is not a weekend batch. This is a evening batch. Uh, Vijay Raghavan, towards the end of polity, I'll tell you what exactly is my opinion on the preparation plan. But yes, whatever is being taught here, that should be more than sufficient. Uh, that is not required to be known, frankly. The laws were made, and the Article 239A was made to deal with a provision for the Legislative Assembly for Pondicherry, where the Parliament by law can provide for the election of the members or nomination of the members for Pondicherry. And the law was made so that even the UTs can have a legislative assembly. So the law contains all those provisions like the LG's appointment, how many ministers, etc. Administration of UT, Shreya, or administrator? Administrator of UT is the person appointed to take care of the union territories. Okay. Now, let's come back to our discussion. First up, so yesterday we were discussing the scheduled castes, and now scheduled tribes. How to identify scheduled tribes? It's a very simple process. Firstly, scheduled tribes are religion neutral, meaning they do not they do not confide themselves to or ascribe themselves to any religion. They can be of any religion. They can be uh, a Hindu, a Christian, a Muslim, etc. Now, the Article 342 talks about the scheduled tribes, and the president will publish the list, and the list is called Constitution Scheduled Tribes Order of 1950. In some places, you will find this mentioned as 1958 also, because the final list was published in 1958, and hence 1958, but the list is referred to as the Constitution Scheduled Tribes Order 1950. And modifications in the list, Parliament can make modifications. Right? Now, what's the criteria? The criteria to identify scheduled tribes is those communities which have been living in an isolated fashion, and those which are vulnerable communities. So, isolated and vulnerable. This is the criteria to identify the scheduled tribes. And this identification is done by the Anthropological Survey of India. So, identification by Anthropological Survey of India, right? So this is for the scheduled tribes, not much complicated, very easy to understand, right? And I will just remind you once again that scheduled castes and scheduled tribes are not getting reservation on economic grounds. The reason for their backwardness is not economic criteria, it is other criteria, as being vulnerable groups, as being isolated, facing historical injustice of untouchability. So please do not make any kind of suggestion that economic criteria should be involved here. Now, because economic criteria's involvement may not actually take away the backwardness that they face. Third category is the SEBC. What is that? Socially and educationally backward classes. SEBC or OBCs. Other backward classes. Okay. Now here it is under Article 342 capital A, and interestingly, for OBCs, center and states can have their own list, right? Separate list. Both center and states can prepare separate list. This means that you are there's a possibility that you may be an OBC in your state, but not at the central level. You may be categorized as OBC in a reservation for government jobs at the state government level, but the same may not be there for the central government level, or vice versa. That is possible for OBCs. For SC/ST, it's not possible. Now, here the criteria is fourfold. Number one, there should be low social position. Number two, lack of general educational advancement. Okay. Number three, inadequate representation in public employment. Inadequate representation in public employment, and also inadequate representation in trade, commerce, and industry. These are the fourfold criteria to identify the OBCs. The respective state governments can identify, the center can identify, they can find out, they can set up a committee or a commission to look into these criteria, and then can notify whether a particular community will be OBC or not. Clear? So any issue that you may have with respect to your OBC criteria, please contact your central or state government, right? Request them to categorize you as OBC. Clear? So this is the criteria for OBC. These words are not defined anywhere. When the government looks into it, it may, on based on its personal, I won't say agenda, based on the opinion, right, of what it feels, can categorize any community as an SEBC. The criteria is the same for center and states. Okay. The only point of difference is that you may have a very low social position, or your community may not be representing itself adequately in the state government level, but could be there in other parts of the country, and hence could have a very proper representation at the central level. So that could be different, right? Now, see, low social position is a concept wherein, in general, what we perceive is that a group of people are not in substantial proportion, and in a setup where in a democratic setup where vote bank matters, if you have insufficient number of people, you may not have the capability to modulate or even affect the politics of the area or the society or the country. That refers to low social position. uh, Vulnerable tribes, etc., Godavari, social issues. That is not, in fact, this also I am giving you additional information which was not required, right? So let's not do a research here. Other things will be told to you in your social issues classes because it is not a part of polity per se. But I wanted you to know that this is a rough criteria for us to know, right? Everyone. Uh, Shashank, again, I think you are getting confused here. This is for OBC, this is for scheduled tribes. They have been isolated and vulnerable. Did we refer to education here? I'm not sure why you get confused with education and money. The criteria needs to be followed, right? It is not subjective. We'll come, yes, Lakshmi, third point means government jobs. I mentioned public employment. My bad. Public jobs. No produce. That will not be possible. A scheduled tribe is a scheduled tribe. Okay? That will not be considered. Kavanagh triple test for OBC is not required for you to know. There's a concept called triple test. Again, that would be uh, a bit too much of information, and we'll be delving into areas and domains which are not required for us to know, right? But just that somebody is asked. So triple test for OBCs is a concept that came up in Krishnamurti case of 2010. Okay. So the idea is how to identify OBC. Number one. Now please everybody follow it. Not important for the examination, but please hear me out. Number one, you have to establish a commission to conduct rigorous empirical inquiry, data-based inquiry into the nature, the implication of backwardness, right? Point one. Point two, then to specify the proportion of reservation required to be provisioned. Number two. Okay. And number three, the reservation should not exceed the aggregate reservation, which is 50% of total seats reserved for SC/STs and OBCs taken together. This is the triple test. This is largely used in the case of local bodies, not with respect to the government jobs. This data I have given is sufficient. If you want to do more research on, say, what is anthropological survey of India, you can do your own research. If you want to find out what are various kinds of tribes, social issues classes is the class where these things will be discussed. So I would request you not to waste time, or else we'll get trapped here and I have to take 3 hour extra session on just dealing with these only, right? So let the concerned person deal with those issues, and let's move on to what we have come here to learn, right? And nobody can convert themselves into any other category. Are we clear? These categories are ascribed through birth. If you move out of the religious fold, you lose the SC status. That's it. Otherwise, don't say, sir, I identify as a scheduled tribe or scheduled caste, etc. Are we clear? You can't identify as somebody here. These are ascribed through birth, and the only thing would be if you move out of the Hinduism, Sikhism, Buddhism fold, if you convert to some other religion, you will lose your SC status. End of story. Done. Okay. You don't need to mug up all this information, not required. But basic criteria you should know, at least roughly, so that it can be, if it is asked in the interview, you may be able to respond. Marrying somebody, etc., will not change your personal status. Are we clear? An SC person marrying say some other caste person will not change their status from SC to any other caste. I hope this is also clear. Now, we did not have reservation for backward classes in the country vis-a-vis the OBCs. So we had reservation for SCs and STs. But in 1953, I'm talking about just post independence. In 1953, there was a commission set up, the first ever backward classes commission. That was called the Kalelkar Commission, because the chairperson of the commission was Kaka Kalelkar, and hence it was called the Kalelkar Commission. That Kalelkar Commission was set up to look into whether we can give reservation to backward classes, the other backward classes or not, barring the SC/STs, OBCs, or SEBCs. So that first backward classes commission was in 1953 to 1955 under the chairmanship of Kaka Kalelkar. But the commission gave an astonishing amount of reservation. 75% seats should be reserved for other backward classes. Now, this was a bit too much. Of course, this could not be accepted. 75% seats being reserved was too much of expectation that the government would ever agree to it. Now, once the commission was set up, the recommendations came like this. No interest was taken by the governments to implement any of those reservations. But then in 1977, Janata Party came to power. Janata Party was a group, it was not one party, it was a group of all these socialist parties largely, which thrived and on the support of the other backward classes in the states, right? So their vote bank itself was these OBCs, right? Unlike say some other party, every party has some kind of typical vote bank, some fan following, right? For a long periods of time, Congress used to target a certain community, like BJP targets certain community. You go to say Tamil Nadu, certain communities are targeted. You go to Karnataka, same thing. Go to UP, same thing happens, right? So 1977, when Janata Party came to power, they showed a lot of interest in the improvement in the lives of the other backward classes. So a commission was set up under the chairmanship of BP Mandal, the former CM of Bihar, the Chief Minister of Bihar. This commission was appointed in 1979, gave a report in 1980. But when it gave its report, in the meantime, the Janata Party had collapsed because of their infighting and stuff, and Indira Gandhi had come to power. Elections took place. Indira Gandhi had no interest in implementing these kind of reservations. So the plan was shelved. It was put in cold storage. But this second backward classes commission made a recommendation that reservation of OBCs up to 27%. 15% for SCs, 7.5% for STs, 27% for OBCs, totaling reservation to 49.5%, because Supreme Court in 1964 had said that reservation should not cross 50%. Okay, so in a lot of places you will find this as 63. The judgment came in 64 actually, the Bharat Shah case. So that is where the Supreme Court had said, and they give a logic that reservation is an exception. What is a norm? What is a standard procedure? That we will not discriminate in government jobs, but we are discriminating. So reservation is an exception. How can exception become more than half? That was the concept of 50%. That reservation is an exception. So it should always be less than 50%. Anyway. But when the VP Singh government came to power after the loss of Rajiv Gandhi in the elections in 1989, then VP Singh government implemented the reservation, the report of Mandal Commission, and implemented the reservation for OBCs. Up to 27% seats were reserved. Now, just one more point here. Uh, when this reservation was implemented, it was immediately challenged in the court, and the matter went to court, wherein the court, in the landmark Indra Sahni case, also called the Mandal case of 1992, gave some guidelines. Okay, some guidelines had been given. Now, guideline number one. So, what's the guideline number one? The guideline number one is that Supreme Court said that, see, and this is one of the biggest misconceptions that lot of you may have, I'm sure of it, because I saw this statement yesterday. The biggest misconception is that the reservation cannot cross 50%. No, no, no. Let me just clarify what Supreme Court has said. In the Indra Sahni case, Indra Sahni was the name of the lawyer. In the Indra Sahni case, Supreme Court had said that the quota should not cross 50% and if crosses 50%, Supreme Court can review it. Are we clear now? Did we understand the point here? Reservation should ideally be 50%. If you make it more than 50%, then judiciary can review it. That is the full statement. So people take half of it and quote it. If you quote half the statement, then it makes no sense, actually, right? Then a lot of reservations can be deemed to be invalid, violating Supreme Court's order. But no, it does not. So you go to Tamil Nadu. In Tamil Nadu, reservation is 69%. It is all allowed, right? So the point is that the reservations can cross 50%, but if you make it more than 50%, Supreme Court will review it, whether it is justified or not, whether it is required or not. I hope this point is clear for everyone now. All clear? So this is the first criteria. Now, second point was, the court also said that if we try to identify, if the government tries to identify based on these criteria, certain communities as socially and educationally backward classes or OBCs, then the Supreme Court can review it. What is the criteria? Was it required or not? Was it justified or not? How have you given that community the tag of OBC? So first one says that the reservation will be questioned. Second one says that when you give a tag of OBC to a certain community, we'll question that also. Based on what data are you giving the tag? Second point. Third point. So the scheduled castes and scheduled tribes, their reservation is not based on their education qualification or their economic criteria, because they face a different kind of backwardness, right? So even if there's a person who is say highly educated, right, he or she still may face discrimination at the hands of others because he or she belongs to a scheduled caste community, right? It is possible. So that's the whole point. But for OBCs, because they have not been facing that kind of backwardness, their backwardness is largely related to their educational and economic backwardness. So if your economic level improves, the status changes, your backwardness also goes away. You are no longer backward. So the Supreme Court said that, and this was also something that the Narasimha Rao government had suggested, that we should try to find out, identify the creamy layer What is a creamy layer? In the panchayats also we had seen this term. Creamy layer means the socially advanced groups. Socially advanced groups are called creamy layer. So basically the elite class. Like if you take milk, cream floats at the top, right? Cream floats at the top, and in the same way, in the SEBCs, the topmost layer, the elite people there, they need not be given the benefit of this reservation. So, to find out this, a separate commission was formed by Supreme Court, or the orders of Supreme Court. Uh, Retired Justice Ram Nandan Prasad Committee was formed. This Ram Nandan Prasad Committee was given the task to identify the creamy layer. What will be the criteria based on which certain categories of people will not get the benefit of OBC reservation, right? Now, once this committee gave its recommendation in 1993, then we incorporated the concept of creamy layer in the OBC. This is a list of people who will not get the benefit of reservation in OBC, in government jobs for OBC category. You don't need to mug up this information. It is not required. UPSC anywhere never asks questions from reservation policy. They may ask you a factual question like they asked this time for the first time ever in the last 10, 20 years. But they will not ask you questions on these. So don't worry on that. But just to get information, kids of those people who are holding constitutional posts like president, vice president, etc. Then group A, group B officers, their kids, people of the same rank in the army, navy, air force. Then professionals like doctors, lawyers, engineers, artists, etc. Then persons engaged in trade, business, industry, people holding certain land above a certain limit, and people having a gross income of more than 8 lakhs. In 1993, when this concept came into picture for the first time, the original limit was just 1 lakhs, just 1 lakh. Later on, the limit kept on getting modified, and initially the idea was to upgrade the limit every 10 years, not so quickly, every 10 years, but later on we started upgrading the limit to every 5 years. So in 1993, the limit was 1 lakh rupees. In 2004, the limit was increased for the first time to 2.5 lakh rupees, meaning people with an annual income, the family income of 2.5 lakh rupees or above, will not get the benefit. Then in 2008, it was made 4 lakhs. In 2013, it was made 6 lakhs. In 2017, it was made 8 lakhs. There are demands now to make it 12 lakhs, though some groups are saying make it 15 lakhs. Now, if you make 15 lakhs as the limit to get benefit of reservation, then a better thing would be to make it 1 crore rupees only, right? This is India we are talking about. 15 lakh rupees of family income. It's not a small amount. I'm not sure how 15 lakh rupees will classify somebody as poor, or even 12 lakh rupees as a poor person. So basically, if you see what happens is, if you have very high limit, then the problem is that most of this will be cornered by the upper middle class and the middle class, because they have the resources to send the kids to good schools, colleges, coaching institute, money, etc. for that. A poor person will not. So ultimately, the benefit only comes back to the upper middle class and middle class people, and not to the poor. So that becomes very high, right? So lot of people uh, whose income falls under 8 lakhs, they may not get the benefit of it. It will largely be those people who are, say, living a pretty decent and sufficient life. The real poor may not get the benefit. That is a concern, right? So this amount is very, very high, extremely high, right? Uh, to tell you, it almost bottom 50% people of this country are earning less than 10 lakh rupees. So are you trying to say that the bottom 50-60% people need reservation? That's a very big amount of people to be striving for very few seats. Problem. Anyway, that's again for the government to decide. Why should we invite trouble by judging this criteria? Then one more thing. What is Article 16 Clause 4? Any idea? We saw this yesterday. This is the article which deals with the reservation policy in government jobs. This is the article which provides an exception that the government can give reservation if it feels that you are or your group is not sufficiently represented in government jobs. There is also an Article 335. Article 335. What is that? Let's read. Don't read this paragraph. Read the first paragraph only along with me. I'll explain first. The idea is that SC/ST reservation, right, will be given. Okay, no problem. But you have to ensure that while you are giving equal opportunities, don't hire any person. So the idea should be that administrative efficiency needs to be maintained. There is a minimum level of performance that is expected from a government servant. That needs to be maintained. So the claims of members of SCs and STs shall be taken into consideration consistently with the maintenance of efficiency of administration. Now, what is this efficiency of administration? This is not defined. Nobody knows this. How will you check somebody's efficiency in administration? There are no marks, right? And if you look at the appraisal report of every civil servant, most of them are getting outstanding rating only in their performance. So Supreme Court said that see, the reservation should also be read with ensuring that don't hire any person, hire only meritorious people. Again, Supreme Court has tried to improve its behavior by trying to understand the aspect of merit. But this is a very archaic and obsolete kind of idea. Look at your life only. All of you sitting here with an aspiration of clearing UPSC. Did all of you get cent percent marks in your 10th standard? Of course not, right? A lot of you did not. But does it mean that you cannot clear UPSC? Have you not seen examples of people not getting good marks in their 10th and 12th and still clearing UPSC with a very good rank? It does happen, right? Marks can never be the ultimate estimate of a person's performance. And Supreme Court has agreed now. But in those days, Supreme Court said that, see, we will give reservation. Of course, the state should, but it should not compromise with the maintenance of or the quality of administration. And how to measure it, nobody knows. There is no criteria. Anyway, once this was said, later on, the parliament said, no, 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 no. We don't believe in all this nonsense. Parliament modified the article and the second paragraph was added by the parliament. Second paragraph was not a part of the original article, it was added later on. So in the year 2000, this entire paragraph was added through the 82nd Amendment Act of the year 2000 via this. So what does this say? Provided that nothing in this article, we don't care, shall prevent in making any provision in favor of members of SCs and STs for relaxation in qualifying marks and lowering the standard of evaluation. So government said that, see, we have to provide for reservation for SC/STs and we are going to reduce the qualifying marks if we have to. we are going to relax the or lower the standards of evaluation if we have to. But reservation will be provided. Simple. That's it. Are we clear? So reservation will be provided even if it comes at the cost of what? It comes at the cost of lowering the cutoff, having a different cutoff, having easy evaluation standards. Clear? So see, government did not say that we'll compromise on the efficiency. Government said that we can reduce the marks and all. Clear? So again, please choose your words carefully. You're again equating marks with merit. That may not be a very good standard. You know how we become hypocrites. When it comes to our own marks, then we'll say marks don't matter. Don't have the don't show the true me. But when it comes to others, oh, how many marks? Oh, how easy is it for us to judge other people based on the same parameters we hate when others judge us. Anyway, that is done. Now, one more point. One more point. Uh, for all of you here, I think the real concern that most of you would have is, I think, because I am dealing with an educated group. That's what I believe. I may be wrong, completely wrong. But since I am dealing with an educated group here, a lot of you, I think, would believe in the policy of reservation. Now, those who will not, of course, the only problem that you are facing right now is that you are too embroiled in that. Once you move out of that, then you may view it without any biasness. But anyway, most of you would believe in reservation. Some of you may say that, sir, I do think it is required, but it is not being given to the right people. That could be correct, of course. I mean, if you look at data also, for OBC, for example, 55% people in this country are OBCs. They are only getting 27% reservation. It is still not adequate with respect to their population. But don't we know, near our surroundings, elite people getting the reservation, getting the benefit? Of course. And that is true for every government scheme. You please name one government scheme where the government scheme is not being misused by the rich elite people. Remember the story of this BMW guy who came in a BMW to pick up ration from a ration shop? 1, 2, 3 rupees per kg ration. Of course, it is being misused. This is no exception, right? Now, so as I said, the point is reservation is equality of opportunity. The starting line has to be the same. And most of it also say that once the starting line has been made the same, once opportunity is given and people have entered the jobs, there should not be any reservation in promotion, right? And that's what Supreme Court said, that quota should be confined, limited only to initial recruitment. Please don't take it to the jobs. No, 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 no. That will not be appropriate. Don't take reservation to government jobs in promotions. Clear? Everybody? Last point also. Now, uh, how many of you believe that there should not be any quota in government job, quota in promotion? Tell me. Should there be reservation in promotion? Yes or no? The idea being that once you have entered the job, right, then your backwardness goes away. The stigma goes away, is what you are feeling. Now, that is true for OBC, because OBC's backwardness is based on economic and job criteria. But how will the stigma of an SC or ST go away? Because that stigma is not attached to a job. Have we not seen examples of people facing discrimination based on their SC status despite being in a government job? Yes or no? So that stigma never goes away actually. But the problem is that you will say, sir, do you have any data to suggest like this? Data and facts, very, very important to constantly show data. Otherwise, without data, it's just feelings. And facts don't care about feelings. In 2019, there were 82 Government of India secretaries. How many? 82. 82. Now, if you look at any secretary or any level of government employees, level, secretary, additional secretary, joint, etc., level, you will find that 15% should be SCs, 7.5 should be STs, 27% OBCs, because that is the reservation matrix. It was found that out of these, only 4 were SC or ST. That's it. Just 4 people. They should have been at least 22%, meaning at least 18-20. Now you'll say, sir, this is a topmost post. What if somebody did not have any merit only? Or the person entered the job very late, so could not get promoted because of age factor? Out of 457 secretaries, additional secretaries, and even joint secretaries, now I've entered the middle management level. 457, 12% were OBC people and SC people. 12%. They should be at least 42%. Now, why is this happening? Age factor now goes away. Now you'll say, sir, maybe they are not meritorious enough. See, I told you, marks, very important. Okay. As per government reports and data only, 98% of civil servants get an outstanding rating in their annual appraisal report, performance review. 98% of the civil servants get outstanding performance rating. Everybody is outstanding. Then what is the problem? Why are we seeing that certain categories are not getting promoted? So the problem is, right? No, that is what I said. Work efficiency. Somebody is saying, but the promotions are based on work efficiency. Are you even listening to what I'm saying? Work efficiency, how can it be calculated? Based on your annual rating, right? The rating given by people around you, 360-degree approach. You'll be studying this in your governance classes, right? Sparrow, etc. 98% people are getting outstanding performance rating. Are you getting my idea here? Everybody is being given excellent in their report card. Then what is this issue of lack of merit? If it was the case that 40% employees are getting poor performance, then merit. Okay. So because of these things, it has been a largely accepted phenomena that there is discrimination in government jobs also. There is. And because of this, the parliament, to get around the Supreme Court's guideline, again modified the article and added Article 16, Clause 4A. This is the reservation in promotion. But it is only for SC/STs. It is only for SC/STs. Okay? There is no reservation in promotion for OBCs. Let me clarify. Only for SC/STs. Now, once this was made, then you would say, then, sir, If the reservation is there in promotion, then how is this happening? Because of Supreme Court's interference. In 2006, when this aspect was challenged, right? When this aspect was challenged, the in the court, the Supreme Court said that okay, see, firstly, state, you cannot pressurize the state into making reservation for SC/ST in promotions. But if the state wants to make reservation in promotion, you have to perform three tasks. Number one, find out the current backwardness of an SC or an ST. Meaning, the SC/ST who wants promotion has to prove that he is still backward. Please prove it. Show it to us. How will a person show that? How will this show that he is backward? Should he carry a camera everywhere? Right? It is almost impossible. The forms of uh, discrimination are so subtle. You are sharing food with everybody. An SC person comes and sits in near you. You don't take food from his tiffin. What is that? How do vegetarians behave in front of non-vegetarians? Right? The ones who are strict vegetarians. Same thing. Forms keep on changing. Difficult to estimate it. Now, don't think a senior government employee will carry a camera and record all these activities. And somebody who is facing that is the best person to know. Sometimes it can't be explained. I think women here will understand this point better. So, girls normally keep on saying that when we go out on the road, people stare at us, making us uncomfortable. Now, as a man, and all the people here, I speak for all the men here, it is impossible for us to know what this means. We can empathize with you, we try to sympathize with you, but having empathy that somebody is staring at you to make you uncomfortable, uh, we don't understand this idea because we have never felt it, right? Those who are going through that problem are the people to understand the problem. The exact same thing, right? An SC person is the best person to tell you that it exists. The vibe is still there in a very subtle way, right? So that is why uh, it is difficult to define it. If you want me to give you a definition, that oh, if you ask a woman, prove it that his gaze or stare made you uncomfortable, she may not be able to prove it through scientific rigors. That may not be possible. Same thing here. But look at the stupidity of the courts that they are saying, prove it. Data. Show me how people are still treating you as untouchable. Of course not. And a common person dare not treat an IPS officer as untouchable. Do you want to end up in jail or what? But within their job, the senior, the colleague, the junior, they do in subtle ways. Anyway, then second criteria was a more logical one, cadre-wise representation of SC/ST in government departments. So the whole idea is that every group should have proper representation in the government jobs, proper representation based on their population. So the Supreme Court said, find out if at any level of government job we have sufficient SC/STs, then I don't think they need reservation. That was the idea. If we do not have sufficient SC/STs, then reservation is required. Then I agree. Fair enough. Again, the Supreme Court sang the same old story. Third point, that if you are giving reservation in promotion, please find out the effect on the administrative efficiency. But the point is, how do we calculate it? There is no exact quality or quantitative metric to calculate it. Because if you rely on the progress report, it's all outstanding. Anyway, this judgment was actually challenged. Finally, in 2018, better sense prevailed in Supreme Court and the first criteria was cancelled. This was later on cancelled in 2018 by Supreme Court. So in the Jarnail Singh case, Supreme Court said, okay, this may not be possible. Thankfully, Some advocates there could help them understand that it is not practically feasible for an officer to prove how they are still facing backwardness and discrimination. But Supreme Court added one more criteria. This is a kind of a creamy layer criteria, right? Kind of creamy layer criteria in SC/ST. It works like that only. So let me explain this to you. Let us say there is an SP, or there are two SPs. One SP belongs to, let's take for example, some scheduled tribe community. One SP belongs to Topo. The other SP belongs to Murmu. There is a third SP who is an Orang. These are all scheduled tribes. STs, communities in STs. Like in your other caste groups, you have various subcastes, same thing. All of them are SPs. Now we have to give them promotion. Let's say we have to make them SSP. Next criteria. Some states may not have SSP, so DIG. Understand that? Next level of promotion. Let's assume DIG only for the sake of easy understanding. Now, the Supreme Court says that before giving reservation in promotion, please find out of all the DIGs, how many Topos are DIGs, how many Murmus are DIGs, and how many Oraons are DIGs. If 2 Topos are DIGs, 5 Murmus are DIGs, and 1 Oraon is a DIG, then give reservation to that community only which is not adequately represented. Are we clear? Everyone? So in this example, please tell me which community will get the reservation. Tell me. TMO, Oraons. Absolutely correct. Oraons are the least represented. So we have only one DIG who is an Oraon, and hence this person should get the benefit of reservation. Just a sec, guys. Okay, so this person should get the benefit of reservation. I hope we have understood this point, everyone, right? And just to also end our discussion on reservation, on a clarification, a very important clarification, reservation is not your fundamental right. Please don't have this misconception that it is your fundamental right. No, 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 no. It is not. Clear? Reservation, both reservation and reservation in promotion, it is not your fundamental right. The state may or may not provide for it. Okay? And the courts have said that if the state wants to provide for it, then it should collect data, collect quantifiable data, measurable data should be collected. Reservation is a special provision. Reservation is a positive discrimination. Reservation is an exception. Reservation is what? An enabling provision. It is an exception to the right. What is a fundamental right? Let's not forget. Fundamental right is that we will not be discriminated against. That is the fundamental right. Are we clear? The right is that there will be no discrimination, equality of opportunity. So reservation is an exception to equality of opportunity. Clear? So this is how it is. So you cannot claim exceptions. It depends based on identifiable metrics and data. Now we are done with our topic of reservation. Of course, we also had the EWS reservation in government jobs, which has been upheld by the government. Done. Prem Kumar, that will not be required for the classes. Explaining the process of reservation, how vacancies are filled, no, not really required. Solve this question. Read it. I'll launch the poll later on. Launch the poll now. 15 seconds. Mark your answer quickly. Okay, very good. Article 335 defines efficiency. Yes or no? Tell me, does it define efficiency? Okay, great. Nancy is saying yes. Why yes, I don't know. But I think I had mentioned also. Not defined. So, anyway, it does not define. So, this is wrong as a statement. 2 is correct. 2 is correct. 2 is correct. No, 2 is not correct. 2 is incorrect. And 1 is correct. Supreme Court of India has held in some judgments. What some judgments? Indira Sani case. That the reservation policies made under Article 16 Clause 4 would be limited by 335 for maintenance of efficiency of administration. Done. Okay. Mayank Padwani, how many slides have been covered, sir? Till last slide. What kind of question? How do I address this, sir? Maybe 4 or 5 slides. Ashay, you face difficulty in learning articles. What to do, sir? You have to memorize, sir. Ask the right question in the class, sir. Right? Put in the effort, sir. Which class are you in, Ashay? Firstly, tell me this. I asked you last time also. Lakshya. So that means there's a children of SCST officers group A, B, C. Uh, I don't know of that, Lakshya. So I have not heard of this rumor also. This is a self-created rumor, I think. You are in class 9, Ashay. Oh, listen, just relax then. Calm down. Just let it flow. If you are in class 9, okay? Let it be. Just come and enjoy this process of learning. You have plenty of time to revise. Amitansh, with the sir, see anybody proposing AI, the problem I think Justice Chandrachud rightfully pointed out that AI also has a problem that AI is based on human behavior, right? It learns from us only, and this means what? When you are saying it learns from us, this means that you are saying that it learns from our biases, our prejudices as well. No, Abhishek. Prem Kumar, because nobody met the qualification criteria, the cutoff standard. Okay. What else? Let's move on now. Now, Article 17, untouchability. So, this article talks about imposing a strict ban on untouchability, making it forbidden. So, untouchability is now abolished. And if anybody is found practicing untouchability in any form, they will be punished in accordance with her law. Asha is in second year, guys. Please, not class 9th. Mistake by chance in typing key. Second year, class 9th. How is there a mistake? But anyway, okay. Then I understand it. These are reasons why the class gets delayed. Anyway, so untouchability is an offense, right? Offense, which will be punishable with a law. Where is the law? The article. This is Article 17. That's it. Done. End. Khatam. Next is Article 18. Where is the law? There is no law. The expectation is that the parliament will make a law. Are we clear? So, whenever there is any article which requires an additional act of the parliament, those articles are referred to as non self executory articles. Non self executory. They are not executable on their own. You require a law to comprehensively execute it. So, if I tell you, don't kill anybody, killing is wrong, you'll be punished. But I have to tell you, you will be punished with what kind of punishment, what should you not do, etc. So, that is where a law is required. And a law has been made, don't worry. This is the law that is called PCRA, originally called Untouchability Offences Act, but now it is called PCRA, the Protection of Civil Rights Act 1955. Now, see, untouchability as a word is not defined in the Constitution, but we know the reference comes from the scheduled caste communities facing discrimination. So, very loose definition can be a practice largely amongst Hindus which looks down upon members of certain communities solely on account of their birth, solely based on where they are born. Now, I just want to give you some examples, not just in India, but internationally also, where in other countries there are such communities which face a similar kind of discrimination, like Burakumins in Japan or Baekjeong in Korea or Cagots. Cagots in western France, northern Spain. Cagots were people who used to make toddy, desi liquor, right? Cagots. Baekjeongs were the meat sellers in Korea. Or even if you go to Tibet, Ragyappas. Ragyappas also face discrimination. Tibet. Now, coming to what is this law PCRA treats all these things as untouchability, right? For example, enforcing religious discrimination. Religious discrimination refers to a discrimination where people are facing a challenge or people are not being allowed to enter a place of worship, right? That's called religious disability. Enforcing social disability, meaning you are denying people access to shops, right? Or from practicing any profession, occupation, trade, or business. Refusing to admit people into hospitals, refusing to sell goods to people, or also trying to incite people to practice untouchability, telling other people that please practice untouchability, it is very very nice as a practice, etc. Trying to justify untouchability historically, morally, socially, maybe philosophically, on any ground. All those things are untouchability. What's the punishment? A huge jail sentence of 6 months and a very big fine of 500 rupees. But if you are a repeat offender, then 2000 rupees or 2 years. One more thing. What is this second point? I want the law, the section, the subsection. Okay, Manikandan, BK Vibhu, Susmita, Nikhil, P. Chandranath, Pooja, Mayank Badwani, Simran, Satyendra, Yuvraj, K. Mahesh, Pooja. Okay. Some of you know, others almost there, and some of you are making some wrong guesses completely. This is section 8, subsection 1 of RPA 1951, wherein mere conviction is sufficient reason for disqualification. You don't even need to send them to jail, right? Disqualified for how many years? Tell me. 6 years plus any jail term if it is there. So that is it. Then, now normally in the court system, please tell me, what is the concept? Don't we follow the concept innocent till proven guilty? Yes or no? You are innocent till proven guilty, right? In the PCRA, that is not the case. You are guilty. The court will operate on the presumption, we presume that you are guilty. You have to prove otherwise, that you are not guilty. Are we clear? So it's exactly the opposite of other laws. That is why the offense is cognizable offense. What is a cognizable offense? Arrest without warrant. So there is no need to get any warrant. The police can directly, based on the complaint, come and arrest you. Are we clear? A cognizable offense. And is also non-compoundable. What is non-compoundable? What is a compoundable offense? We discussed that in the Lok Adalat. A compoundable offense is a petty offense, small, where out of court settlement is possible. But a non-compoundable offense is where the matter must go to court. You cannot settle the matter outside the court. Not possible. Okay. This is the PCRA 1951. 5. There's one more law. Now, this PCRA only prevents or protects people from untouchability. Clear? Untouchability. There's one more law which is called the SC/ST Prevention of Atrocities Act. This law basically provides for preventing any kind of atrocity against a scheduled caste or a scheduled tribe person. So this act lists various offenses that are considered atrocities. There are 30 different kind of things that are considered atrocities. For example, if you occupy SC/ST land, right? If you try to publicly humiliate an SC/ST, if you give a false evidence against SC/ST, if you try to uh, force an SC/ST into eating something obnoxious, if you dump something obnoxious and dirty in an SC/ST person's house, right? All these things are called atrocities. And the penalties under the POA Act, the SC/ST POA Act, is minimum 6 months of jail to life imprisonment. In certain cases, death sentence also. Death sentence also. So, for example, if you try to give an act as a witness against an SC or an ST person, and you give a false evidence, false testimony against an SC/ST person, the result of the false testimony is the SC/ST getting life imprisonment. The court, if it finds that you gave false testimony, the court can give you also life imprisonment. And if because of your false testimony the SC/ST got death sentence, the court can give you also death sentence. Okay. And separate special courts are set up for speedy trial, fast track courts basically. And automatic arrests are allowed without any FIR. No prior approval of anybody is required, no magistrate, nothing. Directly, if an SC/ST person goes and complains, the police can directly come to you and arrest you. As simple as that. Clear? Now, as far as law was concerned, there were a lot of allegations of misuse of the law, though there is no recorded data as such of what is the percentage of misuse. But still, because of these allegations, when this matter was challenged, that at least there should be some inquiry. When I go and complain that somebody has made fun of me because I'm a SC/ST person, then the police should at least inquire whether my statements are actually true or not, right? Because if I go and tell the police that I had 10 lakh rupees in my house and the money got stolen, the police will come and inquire whether I had 10 lakh rupees or not in the first place. So in all other cases, the police inquires first. But in such cases, no need of inquiry. So the court in the Subhash Mahajan case 2018 said that, see, there is absolutely no need for automatic FIR arrest. You firstly conduct a basic inquiry to find out if there is merit in the allegation or not. Clear? Preliminary inquiry is a must. And after that, take written permission of the DSP or the SP before arrest. Don't directly arrest people. No. So the court added a check. But when this judgment came, a lot of people from the SC/ST community protested in Delhi that this was diluting the very strong law which was meant for their protection, etc. So the government modified the law, added section 18A, stating that all this is cancelled. Original provisions, meaning no inquiry, direct arrests. We are going back to that. The status quo ante was restored. Later on, the Supreme Court's three-judge bench also set aside the Subhash Mahajan judgment and upheld the Supreme Court's modification. The government's modification. Are you clear? So now we are back to the same original provision of this. Done. Clear? See, just to summarize this point, are SCSTs misusing this provision? Yes, they are. Just like, are women misusing the provision of Dowry Provision Act? Yes, they are. Are rich elite people cornering all the resources meant for poor? Yes, they are. But just because some people are misusing it, we cannot weaken the law. So here, actually, the idea is to firstly collect data. What percentage of people are misusing it? What percentage of people? If you have information, then only can you act. If 5% are misusing it, we can't then modify the law. Sadly, what can we do? Right? The same thing. Maybe, I'm sure all of you must have heard or seen a case where some woman has misused the Dowry Prohibition Act to file a false charge against the husband or the family. But then there are crores of women who have been suffering on a daily basis. Maybe in your own family, there have been cases where women have been suffering, right, at the hands of their husband, but have remained silent. So the point is that when you want to make a law more stringent or weaken a law, we have to see what is the scope and extent of misuse, etc. So that should be there. Okay. Solve this question. Easy question. I'll give you 30 seconds. Guys, please understand. Solve the question, not your personal feeling. I'll tell you why I'm making this statement. There's a important point here. Don't mark the answer based on what you are feeling. Mark the answer based on facts. See, I told you, for a lot of you, untouchabilities, and which of the following categories of rights incorporates protection against untouchability? Untouchability is Article 17. Right to equality is Article 14 to 18. I'm not sure why people mark exploitation. These are different articles meant for different things only, right? So D is the answer, not A. Okay. Now, Article 18, abolition of titles. So very simple and easy. If we are talking about equality, why should people be treated differently by the state? So we won't give any kind of title. No kings, queens, Rai Bahadur, Zamindar Bahadur, Company Bahadur. These titles are not being given now. But except a military title, that can be given, an academic title, that can be given. So military and academic distinctions will be given by the state, but the state will not give any title to anybody. Are we clear on this? Tomorrow, if Byju's starts giving a title, student of the year title, will that be allowed? If Byju's gives a title student of the year based on not academic criteria, based on how good jokes you crack in the class, not allowed? It is allowed. State will not give you a title. That is why I had to add the criteria, because some of you are writing, oh, It is academic criteria. State will not give a criteria. Okay? Byju's is not a state. Pavitra Paramveer Chakra is an example. Prem Kumar, Sir, Ivor Jennings. Ivor Jennings. Ivor Jennings. All these things were before independence, sir. What are you saying? Now, no citizen of India shall accept any title from any foreign state. So we are also not allowed to accept titles from foreign states. Are we clear? For example, back in 1980s, 1988 to be exact, Sunil Gavaskar, the legendary batsman. So you would not know him. Sunil Gavaskar, like say Virat Kohli of the current generation, Sunil Gavaskar in those days, right? So not the playing style, the importance in the team, etc. So the point is that Sunil Gavaskar was being given the title of knighthood, sir, but he refused it, of course, because citizens are not allowed to accept any title from any foreign state. So the assumption is that if you accept it, you'll have to give up your Indian citizenship. Is there any law for this? No, it is not there. Some people claim that, oh, this is a loophole in the constitution, that nothing is mentioned. Why? Nothing is mentioned. But if you try to accept a title from a foreign state, the government of India can simply cancel your uh, citizenship. Keep on crying. There is no law, there is no law. Right? Flying sick for Milka Singh? Master Blaster? What are you saying, guys? State given a title to Sachin Tendulkar? Then go to the Tamil industry, go to the Telugu industry. Every movie credit starts with Thalaiva, superstar, right? Mass superstar, Makkal Selvan. These are not titles. Are we clear? Given by the state. People can call you anything. Such innocence in the minds of our people. Okay. King Khan. Now you'll say, oh, King Khan is there. Wrong. Did the state call him King Khan? Is there a title which was conferred on him? No, right? So it's okay. Now, third point, very important. If you are a foreigner, not Indian citizen, foreigner, but you are working in India and holding some office of profit or any trust under the state, you will not be allowed to accept any title without the president's permission. You can, but you are not allowed to accept it without the permission of the president. That is required. And the fourth one is for people like you. No person holding any office of profit or trust under the state. Let's say you are an IAS officer, IPS officer, IFS officer. You go to a foreign country and the people there give you gifts. Those are not meant for you. Don't take them home. Right? You ask the president first that I am being given this gift, etc. And then deposit them in the public treasury. The gift has come for the government. Okay? So, no person holding any office of profit or trust under the state shall, without the consent of the president, accept any present, emolument, or office of any kind from or under any foreign state. Clear? Okay, so this is with respect to Article 18. And let me tell you, all the people who want to be IFS officer, when you go to a foreign country and you fall in love, it's okay, you can fall in love, no problem. But if you want to get married to a foreigner, you have to get the permission of Government of India. The president's permission is required to marry a non-citizen. Look at the difference in status. Right now, you will be struggling to get the approval of your parents, the other person's parents, etc. But if you clear the examination, government will approve your marriage. Today's motivation. If you want the government to approve your marriage, clear the examination. Okay? Now, coming to this concept of national civil awards. When it comes to national civil awards, there is some misconception that if we are saying the government cannot give titles, how are we getting all these awards? Padma Shri, Padma Bhushan, Padma Vibhushan, Bharat Ratna. These awards were started in 1954. Okay. When Janata Party came to power, these awards were suspended. Janata Party said, what is this nonsense? What is this Bharat Ratna? So some people are Bharat Ratna. What are we? Bharat Pathar? No. No need to give any kind of title like this. Non-discrimination. So from 1977 to 1980, titles were not being given. These awards were not given. Later on, in 1992, this matter went to court that these awards are titles. The state is conferring an award calling you Bharat Ratna, Padma Bhushan. Again, the matter was in court and it was suspended for 3 years. Then Supreme Court said that these awards are not titles. Are we clear? These awards are recognition for a citizen or for non-citizens, for people who contribute towards this country. So every country has a right to appreciate the contribution of its citizens or people in general. So there is nothing wrong. Not titles, but should not be used with name as a prefix or a suffix, meaning should not be attached to your name before or afterwards. Meaning, if you get the award Padma Shri, don't run to Aadhaar office. Aadhaar office, Aadhaar office, please change my name. Please now write my name in Aadhaar, Padma Shri ABC. If you do this drama, your award can be cancelled. It can be taken away. Are we clear? Everyone? Now, look at the Padma Shri criteria. Who gives these awards? These awards are given by Government of India, Center. Okay? Center gives the awards. Padma Shri is given for people who have performed distinguished service. What's the meaning? We don't know. Padma Bhushan, distinguished service of high order. Padma Vibhushan, exceptional and distinguished service. And Bharat Ratna, exceptional service or performance of the highest order. What is the meaning of all these things? Only government knows. Maybe if you appreciate the government, Padma Shri. If you appreciate the government frequently, Bhushan. If you appreciate them excessively, Padma Bhushan. And if you are crazy about the government, Bharat Ratna. Maybe that could be a possibility, because the governments keep on giving these titles to people, awards to people who are their favorite, right? Anyway, one more thing. There is no such limit to how many Padma Shris, etc. But Bharat Ratna has a limit. Maximum 3 per year. Though there is an exception. In 1999, 4 people were given this award. 4 people. Amartya Sen, Jay Prakash Narayan, Gopinath Bordoloi, and Ravi Shankar. Not Sri Ravi Shankar, sitar player Ravi Shankar. But normally 3 per year. Now, please understand this point here. That when it comes to these awards, the center gives these awards. In 1955, Pandit Nehru got this award. 1955, Pandit Nehru. Please tell me who was the Prime Minister of India in 1955? Tell me. Pandit Nehru only. What does this mean? He gave the award to himself. No. Actually, it was said that the cabinet has forced Pandit Nehru to accept the award. He is not willing, saying, no, please, don't give it to me. Don't give it to me, please. But he was forced into accepting this award. Anyway, in 1970, it's like the typical shadi thing. When you go to a place, you say, I don't want to eat more, but you keep on pushing the plate, right? In 1971, Indira Gandhi got this award, Bharat Ratna, for her great contribution. In 1971, who was the Prime Minister? You know very well. She thought that if my papa can do it, I can do it, right? And one more thing, you'll be surprised to know. In 1991, Sardar Patel got this award. In 1990, Rajiv Gandhi got this award along with Dr. Ambedkar. Together, right? So, you know very well. Of course, the contribution of these awards, these individuals like Rajiv Gandhi, is way more than Ambedkar and Patel, of course, right? Indira Gandhi is Indira Gandhi. Her contribution was way too much. What is Patel's contribution, Ambedkar's contribution? Right? Oh, it's okay. So they could wait. Sardar Patel getting this award 20 years after Indira Gandhi. That is justified, right? So tomorrow we know who can get this award, right? If BJP is in power, we know who will get this award. If Congress is in power, we know who will get this award. So it's such a nice thing. That is why there are two suggestions here. Number one, set up an independent committee to give recommendations. Number two, do not confer on past personalities. See, people who have passed away long back, we don't think they need awards. It's okay. I mean, if by 1990 you had not given Patel or Ambedkar the award, it's okay. Giving them this Bharat Ratna does not elevate their status in any form or manner. Clear? Now you have given this award to Sachin Tendulkar in 2014. Imagine tomorrow if you give this award to Bhagat Singh. I'm not sure how it is elevating the status of Bhagat Singh. No, it is not. There are some people who are above these awards. Their contribution to country's freedom or country in general is way above these awards. So it is okay. And because you have given these awards to current people who are currently there and you give awards to these people who are dead now, it is a perversion of hierarchy also. So let it be. Let it be. Are we clear? So Just to point this out again, awards are not titles. So please don't be confused. If any state government, central government is giving some kind of award based on the recognition, don't think of it as titles. Clear? Some state governments do this. They give various kind of awards to their people. So yeah, these extra awardee persons get some extra privilege. What extra privilege are they getting? Like Bharat Ratna. If you're a Bharat Ratna, you are ninth in the order of presidents. That's the privilege, right? That is the only privilege, right? What else are they getting? It is so anybody who is winning this award of excessively good contribution, he is getting some benefit. What is the big problem there? You perform very well for nation building and the nation appreciates you. Not paying tax? Arey sir, don't bring WhatsApp forwards here, please. Don't give me all this information. WhatsApp forward. Please talk facts. Sandeep. Yes, sir. Bangabhushan, Karnataka Ratna, of course, yes. Anuj, relation of awards and titles with right to equality. So, right to equality means equal treatment of all people. There should not be any differential treatment. That is why Article 18 is a part of right to equality. Sir, what am I teaching you, sir? What are you asking, sir? Arshat, UCC and SCST law has no relationship, sir. No relationship. Let me come and teach you UCC. That is why I say at least get information before making statements. Ananya, that is a military distinction. It is allowed. Should we move on now? Solve this question. Very good, excellent, amazing. Shabash India. Not correct. After so many practice questions in the class, taking so much of effort, this is what I get in response. Not reading the question properly, even now. Thank you so much, guys. Amazing. And some are saying elimination is good in this question. Oh, amazing. Bharat Ratna and Padma Awards are titles. Yes or no? Are they titles? Wrong. This is a wrong statement. Somebody is still asking me, sir, why one is correct? Padma Awards, which were instituted in the year 1954, were suspended only once, two times. Wrong. The number of Bharat Ratna awards is restricted to maximum 3. Wrong. All 3 are wrong. What is the answer? D is the answer. Okay? Then what's the point of me making you practice all those things? Wasted my time also. Anyway, let's take a quick break, guys. We'll be back at 11:55. Will that be okay? And we'll have a lunch at 1. Okay. Leaderboard. Just 3 questions. What to show leaderboard right now? I'll show it later on. Once we have more questions. After every question, I can't show leaderboard. Shashank, National Civil Awards. I taught a topic because we were discussing right to equality. Okay. No, Praful. That's also possible, baby. Soyab, there is no such privilege. I think I explained that. Saloni, that is just an award, not title. He is precisely not getting titles, recognitions, awards. Maybe I'm not sure what this means. Holding a title of their caste. What is that? Vani, 2 years is a jail time. Arshat, no relationship. Come at 12, guys. Sir, all these awards were suspended twice. Twice. Okay, let's continue. Now, some constitutional bodies, very simple, very easy, nothing complicated. These are NCSC, NCST, and NCBC. Please remember the article for all these bodies: 338, 338A, and 338B. Okay. So, what is the NCSC? The National Commission for Scheduled Castes. This originally was a body called NCSC and ST, National Commission for Scheduled Castes and Scheduled Tribes. One body only. But then it was realized that the issues, the aspirations, the goals, the objectives, etc., of SCs and STs are vastly different. So we should bifurcate and have separate body for the scheduled caste and a separate body for scheduled tribes. So we bifurcated and created two bodies. One was the NCSC and the other was NCST. Okay. Now, what is the purpose of NCSC? To oversee the implementation of various safeguards provided to the SCs under the Constitution. Basically, promote and protect the social, educational, economic, cultural interests. Interest of which community? Tell me. Interests of scheduled castes, of course, plus Anglo-Indians. Please don't forget, NCSC performs for both scheduled caste people and for scheduled Anglo-Indians. Are we clear? So please remember this information. Don't forget, they perform tasks for both scheduled castes and Anglo-Indians. VK Kush, of course, sir, you have committed a crime. Done. What is the result of the crime? We don't care. Yes, you'll be punished. Now, who are the members? We have chairperson, vice chairperson, and three other people. And they are appointed by the President of India, and that's all we know. That's all we need to know. Nothing else is mentioned. Now, coming to functions that they perform, what kind of functions do these bodies perform? These bodies and similar such bodies perform very similar functions. Number one, investigate and monitor all the safeguards, the articles mentioned in the Constitution. Point number one. Then, inquire into specific complaints. So, complaints. So, now, second point is, if you are a scheduled caste person, then please approach the NCSC. If you're an Anglo-Indian, please approach the NCSC and they will help you out in solving the concern, the problem that you may be facing. Right? Number three, they also participate and advise in the planning process. Planning of the socio-economic development of the SCSTs and also evaluate the progress of the development of SCSTs. Then they present annual reports to the president on how effective have been the provisions of the SCs being implemented in the country. Then, making recommendations. These bodies also make recommendations and discharge any other function with relationship to the protection, the the welfare, the development, and the advancement of the scheduled castes. These are the functions that NCSC performs. Mug up these keywords and write the answer if a question is asked. Do you understand? Do you comprehend this? Please. Okay. Lastly, also important, while investigating the matters or conducting an inquiry into any complaint, NCSC has the power of a civil court. What is the power of a civil court? A civil court's power is what? A civil court's power is to order any person to come and be a witness in front of you. Civil court's power is to do what? To ask any government department, any particular office, government or private office, to submit any document, any evidence. So you have to be a witness, you have to give any document that is required if the civil court asks for it. And NCSC has the power of a civil court because it also looks into inquiries, right? Yes, these are independent constitutional bodies. And a very, very important point is this: Article 338, Clause 9. Look at this. Center and every state government, if you are making any kind of policy affecting the scheduled castes, you have to, shall, mandatory to consult the commission. Before making any kind of policy on the matters affecting scheduled caste, the commission must be consulted. Clear? Okay. I mentioned here the powers of civil court, not important, but you can go through it in case anybody wants to mug up this information. I have already explained what this means. Now, we are done with the NCSC, NCST, and NCBC. Why? Because NCST and NCBC have exact same functions, word by word. Not even a word has been changed, except, of course, in the NCBC, it will be BC instead of SC, and for NCST, it will be ST in case of SC. So, NCST through this article and NCBC through this article, and NCBC is a more recent modification. 102nd Amendment Act. Okay. Anglo-Indians are not scheduled caste people. Anglo-Indian can be of any category. Anglo-Indian is a separate person only. I think I saw somebody was asking me a definition of Anglo-Indian, which was embarrassing to say the least. Yes or no? Is it not shameful to be asking the definition of Anglo-Indian right now when we have already read this topic in the chapter Parliament? Right? Anglo-Indian. Please refer to your Lok Sabha slide. I have mentioned there what is Anglo-Indian. Anglo-Indian is a person, any of whose male progenitors are of European descent. Consultation is, guys, I also want to tell you, I have told this again and again, but I'm not sure what group I'm dealing with here, which is a interesting group. Consultation never means binding. I'm not sure why this question is asked again and again. Only for one case, that is for judges, the Supreme Court has interpreted consultation to mean binding. Are we clear? Consultation is an English word. It does not mean binding. I have mentioned this earlier also. Just like Article 74, right? Consultation, the meaning of it is a normal meaning. For the third judge's case and second judge's case, Supreme Court has defined the word consultation in Article 124 and 217 for appointing judges to mean binding concurrence. If you ever find the word consultation anywhere in your life except those two articles, please assume it is just consulting, not binding. How many times will I make the same statement here? Anyway, NCST, NCBC, they have similar provision, same kind of composition. Everything is exactly the same. If you go and look at the article, if you ever do in your life, you will see the words are also the same. The comma is also the same. Everything is the same. Right? Now, please don't say, sir, are the members also same? Of course, the membership number is same, but different members are there. It's a different body. So I assume that you won't ask me that question, but yes, same 5 members, same purpose. Of course, there it will be backward classes or scheduled tribes. Are we clear? Can we move on now? Life is difficult for some of the privileged people. Trust me, it is not that easy. Right to freedom, 19 to 22. Next group of rights. Okay. Starting with Article 19. Just a quick reminder, there are certain articles which are meant only for Indian citizens. 15, 16, 19, 29 and 30. Okay. 15, 16, 19, 29, 30. 5 articles meant only for Indian citizens. Article 19 is one such article. Look at this. All citizens. Clear? So all the citizens shall have the right of what? The freedom of speech and expression. And let me tell you, all these are sub clauses. Article 19, clause 1, sub clause A, B, C, D, E, F, G. So all citizens shall have the right to the freedom of speech and expression, to assemble peacefully and without arms, to form associations or unions or cooperative societies. This phrase was added through the 97th Amendment Act 2011. You'll discuss about cooperative societies in your social justice classes. To move freely throughout the territory of India, to reside and settle in any part of the country. F has been repealed. It used to read to acquire, hold, and dispose of property. Right? To acquire property, to keep property, and to dispose property. That used to be a fundamental right. It has now been repealed. Discussions later on. And POTB, practicing any profession or to carry on any occupation, trade, or business. Okay, POTB. Now, let's look at, before that, let me again remind you, fundamental rights are not absolute. Restrictions can be imposed on your fundamental rights. One more thing, just to point this out, sometimes there's a misconception. Some of you may say, sir, is Article 17 absolute? If Article 17 is absolute, then how can rights not be absolute? This means that some rights are absolute. Yes or no? Tell me. Right? Is there any restriction on untouchability? Article 17. Meaning, can you practice untouchability in any situation? No, you cannot. But let me tell you, is Article 17 a right or a restriction? You tell me. What is Article 17? Does it give you some kind of right, or does it give you restrictions? Article 17, what right does it give? Tell me. Those who are writing a right, what is a right? Right not to be discriminated against is Article 15 only. Article 17 is not a right actually. It is a restriction. How can not facing untouchability become a right? It's available to you naturally. So the misconception is in the understanding of Article 17. Article 17 is absolute, not because it's a right. It's a restriction which is absolute. Are we clear? So restrictions may be absolute. Rights cannot be absolute. That is not possible only. Right? In any sane society, a right cannot be absolute. It is not possible because our rights will be limited with some other person's right. In case of COVID-19, many treated as guys. Okay, I'll come to that. Don't worry. But let me just clarify. Please don't. How do I explain this? If today, let's say Mr. Prem Kumar in epidemics, sir. Okay. Mr. Prem Kumar, you go to a girl today and tell her, hello, I want to hug you. And the girl says, get lost. I don't want to. Will you go to court and claim that she's treating you as untouchable? Please tell me this, sir. Tell me. You can go to court, of course. Then what will the court say, sir? If the court does not punish you with a jail sentence, I'll be very unhappy with the court. They should. Somebody is saying tight slap. Huh? Okay, judges may not get down to give a tight slap, but yes, that's a problem. So if you cannot go to court to say all these things, why saying all these things in the class? Untouchability, Article 17 is not defined, but we know what the context is. So if you are suffering from a contagious disease, there are various laws which allow you to be segregated. That is not Article 17, sir. Please don't invoke Article 17 in silly places. Right? I hope everybody got the gist now. Clear? Article 17 is meant for a particular situation. Scheduled caste people, historic injustice. Don't try all this in your day-to-day activities. You may face a serious concern in life. Now, Article 19 has restrictions. So many restrictions. So you have one right, and for every right correspondingly, there is a separate clause which lists restrictions only. Restrictions. Here we have same restrictions, same clause, restrictions. But two things. Always remember this point. Restrictions can only be imposed by a law. If there is no law, there is no restriction. Are we clear? Number one. Number two, restrictions have to be reasonable. They cannot be unreasonable. Reasonable restrictions. Now, who decides that? The court will decide. Simple. Let's look at, so the articles here are very easy to understand. The restrictions are the real challenge. So these are the restrictions on your freedom of speech and expression. Look at this. Just look at this. What is the right? Speech and expression. Three words. What is the restriction? 8 different kinds of restrictions. So, one more thing, just to point this out, your freedom of speech and expression includes lot of things, though not mentioned here, but it is assumed to include these things, which I am writing right now. It is assumed to include the freedom of silence. Freedom to express also means freedom of silence, which most of you use whenever I ask any question in the class, right? The freedom of silence. It also includes the freedom of press. It also includes the freedom of information, the right to know. Now, what information? Not your neighbor's phone number, government activities. Because somebody will ask me, I'm sure, that, sir, can I know the neighbor's phone number? No, sir, you cannot. You have to earn it. Then the last is the right to access information over the internet. So one more thing, sometimes courts don't understand the implication of what they say. So back in 2020, Kerala High Court made a statement, or rather 2019 only. Kerala High Court made a statement. Right to internet is a fundamental right. Article 21. Don't make such statements. If right to internet becomes a fundamental right, then I can go to government and claim, give me 100 GB of internet today only. Today, give me fundamental right. We can't do all that nonsense. That's not possible. That is why Supreme Court has rectified that judgment by giving a more appropriately worded judgment. Right to access information over the internet is your fundamental right. So government should not randomly ban websites to deny you information. Are we clear? We have no such right of internet. In the Anuradha Bhasin case recently in 2020, Supreme Court said you have a right to access information over the internet. That's the right you have. Clear? Anyway, let's come to the Prem Kumar. I'm again telling you, sir, can be treated as untouched. That example is wrong. Don't use the word untouchability in any other context, because then the inherent meaning of untouchability gets lost. End of discussion. Focus on what I'm teaching right now. Ignore all that. Now, there are certain restrictions which have been added later on. For example, difficult time now, revision time. Sovereignty and integrity of India. Can you tell me where else has this phrase been added in the constitution? Susmita, Kamlesh, Ananya, Vaibhav, Ruhani, BK Vibhu, Yuvraj, Kavana, Krishika, Vaibhav, P. Chandranath. Correct answer. Others are giving a wrong answer. Others are mentioning preamble. In the preamble, only integrity was added, not the entire phrase. So, for those who do not know, this was added through the same Amendment Act in the oath for ministers. So, ministers take two oaths, oath of office and oath of secrecy. So, in the oath of office, it was added, right? So, this is there. Now, one more change was made, and that change was, or rather, three changes were made through the First Amendment Act 1951. Three things were added. Okay, these three. Let's look at what is incitement to an offense. Incitement to an offense. So before that, let me just ask you a question. If today there is a discussion going on somewhere on should Kashmir be made independent? Okay, a discussion is going on this topic. Please tell me, can we have a discussion on this topic or not? A for yes, B for no. Okay, that's pretty interesting. A lot of you are in full agreement with this. Oh, that's very nice. Some of you, of course, are not. See, Supreme Court has said that discussions of any kind, however annoying they are, however critical they are always allowed. They are always allowed. Discussions, however annoying, however critical, will always be allowed. You can never stop discussions. Second thing, advocacy, preaching something, propagating something. Now tell me, should there be a group which will actively propagate that let's give independence to Kashmir? Will you allow that? No, no, don't be so liberal also. That will not be allowed. If you give independence to Kashmir, uh, that violates Article 1. India is an indestructible union, right? So when you want to preach an idea, it is allowed, but within the framework of the constitution. Allowed within framework of the constitution. For example, for example, let's say, what if there's a group of men who start telling that we want to have a national commission for men? Will that be okay? If there's a group of people who start saying that we want to have a national commission for men, just like a national commission for women, why not? Okay, what's the problem here? Having a commission to look into the problems that men face. What can be a problem there? Tell me. How is it unconstitutional? A lot of you have marked no. I would want to know. It's not okay. No, never. Gender inequality. Don't we have National Commission for Women? How about they are majority? Sushmita, based on the current data, you are wrong. Already in majority. What kind of majority? Numerical majority? No, they are not. Saloni, no, they are not. See, understand it. There are a lot of demands being made, right? Demands are made from various sectors. Your demands are fully acceptable if they are within the framework of the constitution. No problem. National Commission for Men, if you make a demand, it's okay. Is the purpose of the commission to harass women? No. How do you know what's the purpose? To look into the demand, firstly see what their objectives are. If their objectives are within the framework of the constitution, such a demand is okay. Are we clear? Please be more liberal, right? Don't be so skewed in your idea. Understand? It is perfectly fine that they have had privileges. That's not the point. The point is, can we preach this, advocate this policy that we want a separate commission for men? Yes, we can. Simple. Done and dusted. Right? Now, what is not allowed? Can somebody get up and give a speech? Hindus, get up, kill all the Muslims. Muslims, rise, kill all the Hindus. Will that be okay? Of course, this is slightly on the easier side to understand. Incitement to an offense is not allowed. You can't incite people to commit an act of violence. Of course. But Supreme Court has said that it is very, very important to understand that whenever you are inciting people, there should be an actual effect on people. If somebody keeps on shouting on the road, come on, kill everybody, and people are saying, Pagal hai, he's mad, then don't punish that person. It's okay. But anyway, the Supreme Court becomes the judge of what actually is the real and present danger here. But it is not allowed. Now, in the Constitution, there is no definition of hate speech. But the example of hate speech would be this only. When you incite people into committing an act of violence, breaking the laws, then it is not allowed. Then it can be a punishable offense. In the Kedarnath case 1962, Supreme Court has clarified that these two things are okay. Don't stop these two things. Punish for this. Clear? Okay. But it is done many times, etc. Laws will be broken. Rights will be violated. The idea is, can the courts restore those rights or not? That is what we can guarantee. No state can guarantee you crime-free society. It can only guarantee you justice. Now, since we are discussing incitement to an offense and freedom of speech, a very important topic needs to be discussed called sedition. What is sedition? Sedition is under IPC, Indian Penal Code. Section 124 capital A is called sedition. Please answer my question with yes or no. Sedition means anti-national activity. A for yes, B for no. Sedition means anti-national activity. A for yes, B for no. A lot of you believe that sedition means anti-national. Okay, fair enough. Sedition was not there in the original IPC. It was added in 1870. James Stephen recommended the addition of sedition. Right? Filters are for coffee, not citizens. Let's read the definition of sedition, and then we can actually understand whether it is anti-national or not anti-national. Whoever, by words, either spoken or written, or by sign, or by visible representation, or some gesture, etc., whether you write or you speak or you make some gesture, bring or attempts to bring into hatred, hatred, contempt, or exciting or attempting to excite disaffection. If you are trying to bring hatred, contempt, or disaffection towards the country, towards the, tell me, not the country, not the nation, towards the government. Please tell me, is the nation and the government the same? Governments can change, right? Will the nation change? Are you getting my point? So sedition is not anti-national. No, no, no. The biggest misconception created by these governments across the country, these parties, is sedition is anti-national. It is anti-government. They apply some logic also. Britishers brought this law. Why will Britain have any problem with anti-Bharat activity? Let it be. That's what the agenda was, right? They wanted you to not propagate anything against the British Indian government. That is why this law was made, to curb, put down the so-called anti-white elements in our country, our freedom fighters, our politicians involved in national struggle for freedom. Because what was their task? They were actually bringing to light the failure of the British Indian government, the unholy government. They had to be curbed, right? Now look at this. We just saw untouchability also. I'll show you other laws also. You have seen so many laws. Laws normally have punishments up to 6 months. That means 0 to 6 months, up to 2 years, up to 10 years. Look at this law. If you do all this drama, you will be punished with imprisonment for life, lifelong jail, for making statements creating disaffection against the government. For criticizing the government, we can be jailed for life, to which a fine can be added, or imprisonment, which extends to 3 years. Nothing in between. It's either 3 years of jail or life term jail. What kind of punishment is this? I mean, how draconian? It is like James Stephen asked, how draconian do you want the law to be? And the British government said, the best. And he gave the best. Every important leader of our freedom struggle had been to jail under sedition, be it Tilak or be it Gandhi. Everybody, right? Such was the law only, that if I criticize, jail. This law looks perfectly fine for an alien or foreign government. Yes or no? Tell me. This law is perfectly okay for an alien government, because alien government will not respect the people's rights. But our own government, which we have chosen, supposedly democracy, by the people, for the people, of the people. Yes or no? In reality, it offs the people, it fars the people, and of course, it buys the people. No, but we will believe in this definition only, given by Lincoln, that by the people, for the people, of the people. So, in our democracy, we assume that we have chosen you. You are sitting in power because we like you. This does not mean that we can't criticize you. We can and we will. But if we excite disaffection, what's the meaning of disaffection? What is disaffection? This means that the government must be loved. Right to be loved. Nobody has a right to be loved. That's not possible. I think all of you here would know that love can only be earned. There is no right of any person or the government to be loved. You cannot manufacture affection. If the government's policies are progressive for the betterment of the people, of course, we love the government. That's the problem, right? Anyway, uh, this law has largely been misused. Largely misused. We find very rare instances of a genuine use of this law. And also, this law was originally upheld by the court in the Kedarnath case. But later on, what happened was that because of frequent misuse, this matter went to Supreme Court. There was a journalist, Vinod Dua. He passed away a couple of years back. Vinod Dua used to run this show called Zaika India, the original food vlogger. I'm sure you see all these food vloggers on YouTube who go to various food stalls and go crazy when two dollops of butter is added in any dish. When they add more cheese, people go crazy. Oh, so much of cheese, excessive cheese, right? That is what our food joints are basically. But anyway, so Vinod Dua used to later on became a part of The Wire. I won't say what's the agenda of The Wire, but anyway, he would spit venom against the government. Every evening he used to run a show on YouTube. But that's okay now. That's okay. If he does not like the Modi government, it's his right. No problem. He is a citizen of the country. He has voted for the government. He has every right to question the government. And then a case of sedition was filed against him. So finally, this matter, S.G. Wombat-Kere case, came up in the Supreme Court. And the question was, is sedition constitutional? In a democracy, are you telling your citizens, don't criticize me, love me? No, no, no. Sorry. Supreme Court told the government, tell us, what is your stand? Government had its typical stand. What is that? Give us more time. We want to respond. Supreme Court said, okay, okay, okay. Take all the time in the world. Enjoy. Government is very happy. See, again, we have made a fool of the court. Again, we have obtained more time. Harassment to people, right? But court said, wait, wait, wait. Before you leave, let me tell you, till you decide whether sedition is a constitutional restriction, it's a reasonable restriction or not, no new case under sedition will be filed. We are putting a stay on the application of the law. We are putting the law in cold storage. You will not file a case under sedition on anyone. And if there have been cases filed in the past, pending cases, you will not take any coercive, forceful action against any person. You decide, let me know. And then we'll see what to do. So, beautiful order of the court. Amazingly mentioned that yes, take the time, go do your drama of more time, but in the meantime, no new case. So, sedition is gone for good now, right? So, it is not been removed, but it has been put in cold storage right now. It is not to be used. In fact, if you observe the new BNS, the Bharatiya Nyaya Sanhita, which will replace IPC, they have removed the word disaffection and all this drama. Thankfully, they have removed it, though they have increased the punishment. Now it is not 7 years, but up to 7 years. But in the new BNS, it's section 150, which talks about a similar kind of law. But now they talk about terms like if anybody is wanting to cede away from India, right? Moving out of India, breaking away from India, that will be called sedition. So they have modified the definition. But anyway, even if the new law is not passed, sedition will not be applicable now. And there are some genuine issues, vague terms, hatred, disaffection. What are all these nonsensical terms? Hatred, disaffection. It's impossible to define these terms, right? I don't want to name any government, but I'm sure you are aware that in not just center, various state governments, there are ministers and the chief ministers. You ask them a question, they go crazy, full of anger. If you question their performance, yes or no? There are various states where the CMs have simply created a scene where people are not allowed to ask questions. If you ask a question, you are a BJP agent. And if you ask BJP a question, you are a Congress agent. We are citizens of the country. Somebody tell them we are not anybody's agent. We are taxpayers. We are living in this country. We have voted for you. Don't we deserve to know what is wrong? Right? Sadly, that's the case. Then it also goes against Article 19(1)(a). It is an unreasonable restriction, actually. This is not a reasonable restriction because you are saying, please don't criticize me, love me, no dissent. But dissent and criticism are essential ingredients of a vibrant democracy. How can you take that away from a democracy? Right? And poor conviction rate. So let me tell you, the conviction rate is as low as 3.3%. 3.3% conviction rate means what? Conviction rate is a rate at which the court finds you guilty. So basically, when the police arrests you and takes you to court, and the court finds you guilty, that means the police arrested the right person. But if the court finds you not guilty, then the police arrested the wrong person. The conviction rate of or under sedition is 3%. Out of 100 arrests made, 97 are wrong arrests. How is this law not being misused then? This is data for misuse. So I was talking about data for misuse. This is a data for misuse. 97 wrong arrests out of every 100. And then the point is we already have alternatives. We do have Article 352 for armed rebellion. We do have UPA. What is UPA? Unlawful Activities Prevention Act. We'll discuss it shortly. UPA, don't worry. Then we also have Arms Act. There are other sections of IPC. So many alternatives are there. Still, the government loves to misuse sedition, and every party is guilty of it. In 2021, Andhra Pradesh government, highest number of cases in sedition. In 2020, it was Manipur. In 2019, it was Karnataka. In 2018, it was Jharkhand. In 2017, it was Assam. In 2016, it was Haryana. In 2015, it was Bihar. Every state government says, this time I will come first. Right? This time I will harass my people. So there have been cases where the journalists, these YouTube journalists, have been harassed. So I forgot the name of this person again. Manish Kashyap or Pratyush Kashyap, some person, I think in Bihar. So this fellow was used to go to various places and make YouTube videos showcasing the failures of the government. Manish Kashyap. Manish Kashyap. So he was arrested. UPA on him. National Security Act charges. Come on, you don't let the person report, and just because he's exposing your wrongdoings and the faults, the failures, the shortcomings of your administrative policies, you jail the person. How sweet, right? Anyway, so this is with respect to the issues pertaining to sedition. Anyway, the law is gone for good now. If it comes back also, we don't think that the court will allow. Hopefully, hopefully. Now, defamation. Defamation. IPC section 499. Defamation is also a restriction. You can see that here. Defamation. So what is this defamation? So I hope you know these two people. This person is, of course, the heartthrob of the nation. Salman Bhai, right? Salman Bhai is an amazing actor, great acting skills. He loves to make these brain defying, physics defying, loves to make all these amazing movies. Recently, best driver. Yes, of course. Of course. He's an amazing driver also. Sorry, he is not a very good driver. His driver is a very good driver. He does not drive normally. Right. Now, uh, recently, a couple of years back, Salman Bhai made a movie, which was a remake of a South Korean movie, The Outlaws, called Radhe. I have heard that Radhe is, I've heard, I could not muster the courage to watch the movie, but I've heard that Radhe's reviews are very bad, right? Those who have seen Radhe can vouch for it, I'm sure. But firstly, I should ask you a question. Why? Why would you see the movie? Anyway, fans. But who is this person? This person is KRK, Kamal Rashid Khan. He is an even bigger wonder. Kamal Rashid Khan was a part of a movie called Deshdrohi, which is, I think, a testimony to how worse do you want the acting to be. So, if there's a question, how worse do you want the acting to be? Please watch Deshdrohi. Please. No, don't. It could be traumatizing, and then maybe some of your brain cells will get damaged, which could impact your UPSC preparation. But anyway, KRK now criticizes, or as he says, he now analyzes, reviews the released movies on his YouTube channel. Salman Bhai's movie came Radhe. In Radhe, there was this actress called Disha Patni. I'm sure you know Disha Patni. Yes or no? Of course, of course. You would know Disha Patni. Disha Patni is a young actress, maybe in her late 20s or something, or maybe early 30s. I'm not sure. Salman Bhai is of the same age as Amit Shah. So, KRK kept on referring to Salman Bhai as Daddu. Daddu is an endearing term for grandfather. That grandfather. So he said that Disha Patni and Salman Khan, it's like grandfather granddaughter combination. Salman Bhai did not appreciate this joke at all. And allegedly, Kiar Khan said that Salman Bhai has filed a defamation case against him. Defamation. Because his reputation has been damaged. That is called defamation. IPC section 499 refers to defamation. You know one more example of defamation in the recent times? The most eligible bachelor of our country was involved in this when he made a statement against the Modi community, allegedly. Right? So, what's the definition? Any person who by spoken or written word, signs, etc., publishes any accusation, imputation means accusation, on any person with the intention to harm the reputation of the person. And the person making such accusation should have the knowledge that what I am saying is going to damage your reputation. Yes, Lakshya, manhani. So, you are damaging somebody's reputation, man samman. It's a punishable offense. Now, there are two types of cases you can file. Salman Bhai feels that because KRK has called him Daddu, now all these young actresses will not work with Salman Bhai, which will result in Salman Bhai not making any money. That could be a problem, right? So, Salman Bhai will go and file a civil defamation case. He will say, I want monetary compensation as damage. Because of this fellow, 5 people have left my movie. I have wasted money. Like Amber Heard and Johnny Depp. So, because Amber Heard made allegations against Johnny Depp, this resulted in what? Johnny Depp losing some franchisees, which resulted in Johnny Depp losing out money. So he filed a defamation seeking money from Amber Heard. The other kind of defamation is criminal defamation, which was there in this case, where KRK allegedly said that Salman Khan has said now that he is filing a criminal case against me. So I will go to court and say, no, 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 no. I don't want any money from KRK because I am a rich superstar. I don't need money. And nobody is leaving my movies. Right? Perfect nepotism. Nobody leaves my movies. I don't care. But I want to see KRK in jail. That is what will satisfy me. Rahul Gandhi. So the case filed against him was a criminal case where the punishment can be maximum 2 years, up to 2 years. And look at this. Rahul Gandhi was given the maximum punishment, and this is not justified. Anyway, so this is called a criminal defamation. Are we clear? Now, what can be a possible issue with defamation? Issue number one, exaggerated valuation of damage. Johnny Depp went to court claiming that 100 million worth of damage has been caused to him. Imagine somebody makes fun of you and you go to court and tell the court, because this person made fun of me, my reputation worth 10 crore rupees has been damaged. The court says, what is your balance in your account? Show me Google Pay. 34 rupees. 10 crore damage. Get lost immediately. So, of course, you can claim any kind of damage. That's a problem. Number one. Number two, if you cause defamation, multiple cases can be filed against you in multiple places. Let's say you are sitting in Delhi and make a statement causing some defamation. Somebody in Lucknow files a case, somebody in Patna files a case, somebody in Calcutta files a case, somebody in Guwahati files a case, somebody in Jodhpur files a case, somebody in MP files a case, somebody in Gujarat files a case, somebody in Karnataka files a case, Lakshadweep, Andaman Nicobar, Kanyakumari, Chennai, everywhere, Vishakhapatnam, entire country, people have filed a case against you, and a criminal case. This means what? Now you have to go everywhere to convince the court that court, it's one case only, please transfer them to Delhi. Your Bharat Darshan begins without even clearing UPSC, right? This is a problem. Next time, before writing anything, you will think hundreds of times. So this can actually have a chilling effect on your speech and expression. Misuse. Misuse to harass people, right? Then it is, tell me something, in most of your cases, if let's say you have purchased some new dress, new shirt, and you have posted the photograph as your WhatsApp status, Instagram, social media, waiting for likes. But you know how friends are. They'll make fun of you only, right? What kind of shirt is this? Looking like a monkey, etc. Some kind of statement they'll make in the comment section. They'll make fun of you. Or whenever you are with your loved one, suddenly your friends become the greatest stand-up comics, right? Trying to impress the person you are with, making fun of you only at your own cost. Do you go to court and file a case? What will you do? You will feel sad. You will maybe shut down your computer only, log out, right? Maybe close, shut down your account only, delete your account. After a few days, you'll come back again, start the account, again do the same cringeworthy thing of uploading photographs, right? You don't go to court. Who goes to court? Salman Khan goes to court. Nana Patekar goes to court. Arun Jaitley goes to court. This law is exploited primarily by the privileged groups only. Rich and elite only are going to court. Common people have no interest in going to court on this law. They don't have the time. And lastly, think of it. Right from your school days, people do make fun, call you names, tease you. You also tease them within limited, of course, with the limits of decency. Now imagine somebody makes fun of you, say calls you a monkey, calls you a lazy pig, whatever. And now you go to the police. Police, file a complaint. He has damaged my reputation, calling me a donkey. Not the police, whose task is also to investigate crimes of murder, robberies, right? Double murders, rapes, such crimes. In a country where we have limited police, 60 lakh cases pending in the high courts, 4.5 crore in the lower courts, you really expect the courts to leave? Forget, murder, aside. Oh, made fun of you. Come here, come here, come here. Judgment, justice. Is it fair that you misuse the public resources, which is so limited in our country, of police, of courts, to file a criminal case? Right? You are using public resources to settle a private dispute. In 2016, this was actually challenged that it should not be a criminal offense. Why are you sending people to jail? Because if you make an offense a criminal offense, the police gets involved. But our Supreme Court upheld it, upheld as constitutional in 2016 by the Supreme Court. In fact, Supreme Court said that right to reputation is as important as life. Right to life. So it's there now, and these are some issues with defamation, which is also a part of restrictions. Let's take a lunch break. After the break, we'll come back and discuss one more restriction, that is contempt of court, and then some other articles under Article 19, and then we'll move on to 20, 21, 21A, etc. Break, please. Come back at 2:05. And guys, come back sharp at 2:05. Okay? Have lunch, tea, coffee. Shashank, IPC is not important at all. Who said it is important? But I can give you some information, right? So some sections you should know. Otherwise, no. Okay? All queries, doubts addressed. Oh, type of slide, defamation. Okay. This one? Now, one person says this slide, other says this slide. What to do now? Tell me. I am keeping this slide open. Come at 2:05. Okay, break please, guys.